Hi, I'm Dr. Randy Bach. I'm honored today to have with me the Manhattan Contrarian, Francis, aka Buddy Menton, um, and we're going to talk all things contrary. Um, so we're going to start with Buddy is an expert lawyer, and he's also a knowledgeable science adjacent human being with a fair amount of skepticism, as the Manhattan Contrarian name might imply. Buddy, tell us a little bit about what happened. Maybe give us a little bit of the blow by blow of the Mark Steyn, Michael Mann trial.
Well, I think I'm going to start with a little bit of history, so people who don't know anything about it will know where it came from. Michael Mann was a young PhD guy working at the University of Virginia in the late 90s when he published with two co-authors two papers purporting to be a reconstruction of the paleoclimate, old climate going back in years. The first one went back to 1400. The second one went back to the year 1000. And these papers were published in 1998 and 1999. And those papers contained a graphic of what they had found, which became known as the hockey stick. So they show essentially flat, unmoving temperatures for 1,000 years up until the early 1900s, and then rapidly rising temperatures in the 20th century, and not into the 21st, because the papers were published in 98 and 99, so up to the end of the 20th century. A lot of people, and I saw this around the time, the IPCC, the UN's climate body that purports to assess climate, puts out a climate assessment report every 4 or 5 years, and they put out one, I think in 2001, called the Third Assessment Report, which adopted Michael Mann's hockey stick chart as its iconic image, including multiple versions in the summary for policymakers, which is all that anybody reads. So the hockey stick became the proof, the iconic proof from the IPCC that humans are driving climate change. Why is it proof of that? Because the hockey stick showed no medieval warm period. If you say that the recent warming of temperatures is caused by humans, you have a very hard time dealing with the fact that the medieval warm period was warmer because nobody was burning fossil fuels in the year 1000 or 1100. So man suddenly comes out with a chart that shows 1,000 and 1,100 were cooler than the present. All previous reconstructions, all based on, there's the hockey stick. Good job, Randy. All previous reconstructions had showed the year 1,000 and 1,100 were warmer than the present, and obviously nobody was burning fossil fuels then. So if it could be warmer without the burning of fossil fuels then, how do you know that fossil fuels warm us now? So the hockey stick became the UN's iconic proof of that. Well, immediately people began questioning the hockey stick, and I looked at it around the time, and as a litigator, I looked at it and said, oh, I know what this is about. Because one thing we know in litigation is if you want to make a scary chart, all you have to do is meddle with the vertical scale. So if you put that chart back up, Randy, and so a viewer could see it, the entire vertical scale of the chart is from minus 0.8 of a degree to plus 0.4 of a degree. The whole vertical scale of the chart is 1 degree. Slightly over 1 degree. And in fact, since the actual temperatures in there never go below about minus 0.5, the range, the temperatures are said to be less than 1 degree. In other words, it's less than the temperature outside changes every half hour, basically.
Yeah, not only that, but the uncertainty. The light blue is the uncertainty of these calculations. I mean, here we have the year 10,000, excuse me, the year 1,000, and who were the major climatologists back then? You know, I don't know, Thor, Grok. I
In the
mean,
year
it's
1000.
hard to say. Like,
William
what was
McIntyre.
where was the science here? I mean, these are all like post hoc measurements, and what you're dealing with
Correct.
is something with a huge uncertainty level,
Some of
and
this,
trying to
came
pinpoint
out
these.
of
And then the only factual part is in blue. The red is the hockey stick. Am I right?
well, the red is called the blade of the hockey stick, and
Right.
the horizontal blue and green um, line there is called the shaft of the hockey stick. So
Right.
the hockey stick has a long shaft and a short blade, so it's shaped like a
So the
hockey stick.
presumption is there's been more warming here, but it also falls within the range of uncertainty from the previous eras.
Well,
And
yes, and what you are showing is the range of uncertainty that man put around his estimate. But so really he was saying, not only do I know the temperatures are flat, but I know with a high degree of confidence that I am correct, that the temperatures were within about 0.4 of a degree of what I have assessed them to be, and that even at the extreme level of the uncertainty, the most recent temperature is outside that band. That's what this right. That's what man's hockey stick claims to show. Well, so I was starting to say that as a litigator, when I first looked at that chart, I said, well, this is fake, because he has compressed the vertical scale so dramatically to make that blade of the hockey stick look like a sharp upward tick, right, when in fact, if you put some reasonable scale like 10 degrees of temperature up and down, the whole thing would look flat and it wouldn't look like anything. Mm-hmm. And then the question is, how the hell does he claim to know what the temperatures were going back? Well, he says he used proxies. What are the proxies? They come from tree rings, they come from ice cores, and they undoubtedly have some relationship to the temperature at the spot where they are. But how can a few trees in California or in the Gaspé Peninsula, which are actually places where he got these tree ring series, purport to measure the temperature of the world within an accuracy of less than 1 degree? So anyway, people started questioning that. In the period from 2001, when the IPCC adopted this chart, and going forward, several people started to look into this in detail. Now you've put up the form of the hockey stick chart, which is actually the graph that was in that IPCC 2001 third assessment report. That is the actual graph they had in color in their summary for policymakers. So people started to look at it, and interestingly, nobody in the climate science, the official climate science community, all funded by the government, took any critical look at it. They were all thrilled. All of them were thrilled to have this. And so who started looking at it? Two guys, and of the two, really one, Steve McIntyre, a Canadian, a retired mining guy. Oh, but a top mathematician, a top statistician, who actually scored #1 on the Canadian math test for high school seniors, and ultimately was a PhD student in math at Oxford, but had to drop out to support his family, and went into the mining business, and I guess did well there. And by 2001, he was substantially retired and got interested in this and started putting a lot of effort into it and try to find out what makes this hockey stick tick. How does it work? And he started finding all kinds of problems in the data collection, missing data, truncated data, periods of time within the hockey stick when the position of the line in there was only based on one or a handful of trees in some scattered locations and other such thing. But the biggest issue he found was failure to report adverse results in the verification statistics. Now, I don't know how much this is going to mean to your audience. I was actually a math major myself. I don't claim to be an expert in statistics, but there are things called verification statistics where they can give you a handle on whether your result has much or not much validity. And one key verification statistic, which was called, I believe, the RE statistic, although it might have been the R squared statistic, but one of the two, he got a result of 0. Basically, this is a statistic which will vary from 0 to 1. 1 means you have a highly correlated, highly valid result, and 0 means you have nothing. And I think he got 0.02, and he chose not to report it in his paper. And McIntyre came up with that and called him out on it. And his reaction to that was calling McIntyre a human filth, I believe. And the climate science community rallied around him. McIntyre co-wrote his papers on this with a guy named McKittrick in 2003 and 2005. And there the thing sat for a while. Another guy named Abraham Weiner, who was a statistician at Penn State University, took up the hockey stick thing in 2011 and wrote a big paper about it. And Weiner's paper addressed a different issue, which was the uncertainty. And particularly, how did Mann come up with those error bars that you were pointing to a minute ago? Are they correct at the level that he showed them, or should they be much wider? And if the error bars are much wider, then the result of Mann's work would be that we don't know that today is warmer than the medieval warm period, and therefore that makes it impossible to assert positively that the current warming is caused by humans, because clearly there was warming in the past that was warmer, not caused by human fossil fuel emissions. So Weiner did this work, and he asserted that the uncertainty was much greater than Mann showed. And that the medieval warm period could well have been warmer than today, even based on Mann's own data. So there's two big pieces of taking apart the hockey stick. The second one, Weiner, was 2011. Now we come to 2012. Now, meanwhile, in the 2008-9 time period, people may know that Jerry Sandusky, an assistant football coach at Penn State, got accused of molesting young boys in the showers. That was investigated at Penn State. And nothing came of it under the Penn State investigation. And meanwhile, Mann was also investigated at Penn State in the I don't know the exact year. It might even have been before Weiner's report, but after McIntyre's. And Penn State, again, basically exonerated Mann, although, per the trial, it did not actually investigate the issues that McIntyre and Weiner had raised. So we now come to 2012. And in 2012, a guy named Louis Freeh, who was an ex-FBI director, was commissioned to write a report on the Sandusky matter. And he wrote a very scathing report about Penn State and how it had covered up the Sandusky matter. And that came out in July 2012. It particularly fingered the president of Penn State, a guy named Graham Spanier, as being involved in the cover-up. Spanier, by that time, had resigned. He was later convicted of child endangerment for his involvement. So right after the Free Report came out, two guys who are Rand Simberg and Mark Steyn wrote very brief blog posts, one on the Competitive Enterprise Institute site, the other on the National Review site. And Simberg's post basically said, now that the Free Report is out and we know how Penn State covered up Sandusky, it's time for Penn State to reopen the investigation of Mann. I believe the most offensive line in that blog post that Mann cited was a line that referred to Mann as the Jerry Sandusky of climate science. And Mark Steyn also had a blog post. And Randy, I did not, you may have a document there. I did not bring with me something which quotes the blog posts. But the thing that Mann objected to most about the blog posts, or that gave him the best hook for a defamation case, was the comparison of himself to Jerry Sandusky, although both Simberg and Steyn's position was we weren't comparing Mann to Sandusky. We were saying that Penn State has been exposed for its cover-ups, and if it covered up Sandusky, what wouldn't it cover up? It's time to reinvestigate Mann and do a real investigation. Shortly after these 2012 blog posts, I believe they were in July, in October, Mann sued Simberg and Steyn both for defamation, all in one lawsuit. And he also sued the Competitive Enterprise Institute and National Review, which were the hosts of the blogs, in the same lawsuit. So there were originally 4 defendants. And that case was brought in October 2012, and it's been kicking around ever since. It finally went to trial in January in a 3-week trial that just ended about 2 weeks ago. 1 week ago, I guess. There you go. There's a picture of Michael Mann. Scientists ripped Sandusky comparison. So why did it take 12 years for this case to get to trial that was brought in originally in October 2012? And the basic reason it took so long is motions. So there are essentially two, when somebody gets sued for defamation, there are 2 major motions they can make. And in this country, it's very difficult for what's called a public figure to sue for defamation. And there's very good reason for that, because the history of the defamation claim is that rich and powerful people use the threat of lawsuits and the cost of lawsuits as a battering ram to silence their opponents. You might say that's exactly what was happening in this case. Mann, by the way, was completely funded by other parties. He testified at the trial that he never paid a dime for his own legal fees, but the identity of his funders was not revealed. So we still don't know who that is, but it's likely to be some wealthy left-wing people. There are 2 major defenses that a defendant can assert against a public figure. One is called the Anti-SLAPP statute. Now we're getting, Randy, I don't even know if you know what this is, but
I actually know the term.
You've
I'm not
heard
sure I
it.
can recite it, but
so one is called the Anti-SLAPP statute, and the other is called the actual malice standard. Now, the Anti-SLAPP statute is a statute which some states have and some don't, but DC has it. This is DC acting in its capacity as a state rather than a federal enterprise, because the law of defamation is a matter of state rather than federal law. But DC has its own version of state law for things like governing things like contracts and car accidents and defamation. And so they have this anti-SLAPP statute in DC. And SLAPP stands for a strategic lawsuit against public participation. So a SLAPP lawsuit is a lawsuit which is designed strategically to silence public debate. And you might think that's exactly what Mann's lawsuit was here. The defendants made those motions. Now, interesting, Mark Steyn never made the motions, but Simberg, CEI, and National Review made motions under the anti-SLAPP statute saying that it's just a powerful person trying to silence us. His case should be dismissed. Mm-hmm. And then there's
to your point. I just want to show this is the blog post by Steyn and Simberg as it stands today.
Oh, so after the trial they took it down. It was up even during the trial. I never took it down.
It looks like nothing was found at this location. Here's the blog post: football and hockey, Mark Steyn. So that post is not visible here on National Review.
So they've taken it down, and I guess I can't say I'm terribly surprised by that, which is too bad. It may go back up someday. So the other defense that the defendants have, which they can make by motion, is what's called actual malice. And actual malice comes out of Supreme Court case law based on the First Amendment to the federal Constitution. And it is, so it's a matter of freedom of speech. And the actual malice standard says that a public figure cannot sue for defamation unless the defendant had actual knowledge that the statement he made was false. So it has to prove that he had actual knowledge that the statement he was made was false. And National Review, CEI, and Simberg also made motions under New York Times v. Sullivan. Oh, the Supreme Court case is called New York Times v. Sullivan that adopted that standard. And so those three defendants made motions under that. Steyn did not. Steyn said from the beginning, I want to go to trial, bring this on. But these motions then played out over a long time because, and I'm not saying I followed every detail, but they sat for a long time waiting for a judge to rule on them. The judge actually upheld the complaints in the Superior Court of District of Columbia. It went to something called the District of Columbia Court of Appeals, not an everyday court. Many viewers here might be familiar with the DC Circuit Court of Appeals, which handles federal administrative agency appeals. That's not the same court. This is essentially the DC equivalent of a state court appeals court, which they have. So the case went there, and that court again upheld the complaint against these. After, by the way, it took that court 2 years to get a ruling out on that. And then the defendants who had made the motions made a cert petition to the Supreme Court. And the Supreme Court ultimately denied cert. Cert means a request to the Supreme Court to hear it. The Supreme Court declined to hear it. But Judge Alito wrote a long dissent about why they should have taken it and why this is an important case for the protection of free speech.
So before you continue, I just want to make one annotation. While you were speaking, I tried to verify whether National Review did remove that. What I had done was looked at the link from Politico, and so they had a link here of the blog post, July 15, 2012 blog post. This is from Politico, and that led to this spot here, which said looked like nothing was found. However, while you were chatting, I endeavored to check in other manners, and it does still exist. So I want to be fair to National Review in real time here. I'm not slandering them. I don't want any slaps across the face or anywhere else. But the article is there. Just that so happens that Politico put in the wrong link back in 2012. So they have this. Their link has this 30942 sitting in the middle of it, and the actual URL is just football and hockey Mark Steyn with a bunch of dashes in it. And so it still exists here, along with the quote, which I think bears reading, because Mark Steyn really doesn't say that. If an institution, what he actually says is, if an institution is prepared to cover up systemic statutory rape of minors, what won't it cover up? Whether or not he's the Jerry Sandusky of climate change, he's quoting Simberg here, I believe, he remains the Michael Mann of climate change, in part because his investigation by a deeply corrupt administration was a joke. So the investigation into Michael Mann was a joke. This is really more an indictment of Penn than it is of Michael Mann in this sense, and nor does Mark Steyn call him that. He's quoting it. He has a thing in quotes, and he says he's the Michael Mann of climate change, which for Mark Steyn is pretty wry, and an interesting comment in and of itself.
Yes, and I think it's Simberg who initially used the phrase the Jerry Sandusky of climate science, and also that he molested and tortured the data in order to get his results. Well, so the case went to trial. I watched most of the trial. The part that I found most interesting was that the two guys I mentioned in my background, Steve McIntyre and Abraham Weiner, who had found major flaws in Mann's work, which have never been rebutted. And as far as I can tell, and I'm pretty knowledgeable about statistics, I don't claim to be an expert, but I can follow this stuff. I was a math major in college, and I took statistics. They're absolutely right. And both of them testified, and McIntyre testified about the failure to report on the adverse verification statistics by Mann, which I would put in the category of scientific misconduct. And Weiner testified that the error ranges that Mann gave for his statistical work were substantially too narrow and should be broadened. And after he did some work on them, he produced his own chart where based on a different approach, but one he thought was more valid, in which the error bars would be sufficiently wide that that the chart no longer establishes that the modern era is warmer than the medieval warm period, which is critical to the value of the chart. So both of those guys testified. Now, does that constitute molesting and torturing the data by Mann to get a desired result? I believe the word fraud appears in the Steyn post. Steve McIntyre was asked on cross, and he, in his work criticizing Mann, he never used the word fraud. I mean, I guess he's too much of a gentleman to do it in his published papers. But he was cross-examined, and the cross-examiner said, "You never used the word fraud, did you?" And his response was, "Well, he omitted adverse results." And then that question and answer were repeated multiple times. That was the most telling testimony of the trial to me. There was a lot of testimony about damages. A lot of the questions went to damages because Mann said he'd been terribly harmed by this. But in fact, the evidence showed that his salary had increased after 2012 and was high.
I'd like to be damaged like that too.
Yeah, he claimed he had lost grants, but he couldn't actually prove any particular grant had been lost. He didn't have any witness who had reviewed his grant and said, "I declined your grant for this reason." There actually was one guy who was a grant reviewer of his who was called as a witness by the defense, who testified that they were completely unaware of the Steyn and Simberg blog posts and didn't take them into account at all in denying the grant. So Steyn's salary went up every year. He's won all kinds of awards after 2012. He has all kinds of published articles. He's made a lot of money off books.
Yeah, Mann, not Steyn.
Oh, Mann. Yes, Mann. Sorry. So Mann had a complete failure of proof on damages. And I would also say he had a complete failure of proof on the actual malice issue because Mann actually did manipulate the data, and his results were presented in a misleading way. And the word fraud is a fair description of that, I would say. But then, this went to a jury. And so many people watching this may know, but the results from the jury were, they were asked to find two issues, actual damages and punitive damages. So on the actual damages issue, they said, yes, he's been defamed, but he has suffered no damages. So we award him what's called nominal damages of $1. So he was awarded $1 of actual damages, I guess $2, because $1 from each defendant. And then he was awarded punitive damages, $1,000 from Simberg and $1 million from Steyn, which would seem to indicate, since Stein's post was mainly a quotation of Simberg, would seem to indicate that the jury took a dislike to Steyn. That's where it sits now. And one of the questions that people have actually been asking me, and may be of interest to your viewers, is where does this go from here? Like, what happens after a jury comes back? And the answer is a lot happens, and it could play out over a long period of time. The first thing that's going to happen is that the defendants are going to go to this judge. The jury comes in with a verdict, but the case ends at the trial court when the court enters a judgment. So I've just described what the verdict says. Now it has to be converted to what's called a judgment. A judgment is a piece of paper that could be a one-liner. It basically says, Rand Simberg ordered to pay Michael Mann $1,001. Mark Steyn ordered to pay Michael Mann $1,001. That's a judgment, which then it says judgment. Well, a judgment is a very important piece of paper because a plaintiff can then take that and try to enforce it. It can try to use it to seize your bank account if you don't pay it. So, or your house. There is no judgment yet. And there's many things that happen between verdict and judgment. The defendants get to make motions. They've already made motions saying Steyn did not prove his case.
Mann.
On the actual, Mann did not prove his case on the actual malice issue. And they have a very good motion on that. That is not a trivial motion by any means. And the court could grant it. Many courts would grant it. I highly doubt this court will grant it, because if he did it, he would be vilified by all his friends and
DC.
In DC. He would be vilified if he did that. But another thing that they can say is that the punitive damages are unwarranted and out of line. And that is far from a trivial matter. And this may be news to you or to your readers, but there are two Supreme Court cases, one from the 90s and one from around 2003 or 4, which taken together say that punitive damages of more than around 10 times the actual damages are in violation of the Due Process Clause of the federal Constitution, and a court should not sustain them. Well, here the actual damages are $1 or maybe $0. So,
well, you're the math major. How much is 10 times 1?
10. So here the punitive damages are 1,000 times in one case and 1 million in the other. In the two cases, in the two Supreme Court cases, one of them, the defendant was State Farm Insurance Company, who had failed to settle a case for its insured. And the actual damages were 1 million, and the punitives were 145 million, so 145 times. In the other case, the defendant was BMW for some car defects, but the actual damages were 4,000 and the punitives were 2 million. So that would be what would that be? 500 times? 500 times. And the Supreme Court said both of those were excessive. Now, the Supreme Court did not set any clear rules on what to do about excessive punitive damages awards in those cases. Next thing, the whole Supreme Court has turned over since those cases, even though they're only about 20 years ago in one case and less than 30 in the other. So they're not ancient history. But the only judge on the Supreme Court who's still around is Clarence Thomas. And he dissented. Mm-hmm. He said these punitives should be upheld, and the federal courts should not get involved in punitive damages, which are a matter of state law. And for these purposes, DC is a state. Although maybe the Supreme Court may even look at that one differently. I don't know. But the punitive damages issue is by no means trivial as a result of those two Supreme Court cases from about 20 to 30 years ago. And where does the case go? The first place it goes, once judgment is entered, the first appeal is to the DC Court of Appeals. Same court that already ruled against Simberg, not Steyn, because he didn't participate, but ruled against Simberg on the actual malice issue. The actual malice issue as to Steyn is somewhat different, but not enough different that I think it's going to make a difference to the DC Court of Appeals. And again, in the milieu where they find themselves, I would be very surprised to see them reverse. But if Simberg and or Steyn have the stomach to take this all the way to the Supreme Court, where Alito has already written a dissent from the prior denial of cert, explaining why he thinks this is important and basically why he thinks the case should not have gone forward even at that time, it is, I would think, more likely than not that the whole thing will be turned around. Whether that's going to happen, I don't know. I mean, one of the things here is that Simberg only owns $1,001, and he can buy out of this for $1,001. And ask yourself the question. I mean, Simberg is not a young man. He is almost entirely retired, and I'm sure this has not been a fun thing for his life. Steyn, on the other hand, is much more of an activist and a polemicist, and would want to go forward, but he can't buy out of it for $1,000. He could only buy out of it for $1 million. But he does have the problem of how to finance those appeals, and I don't know how he would do it, but I bet he can. I bet he could find somebody to pay for it for him.
Yeah, no, I love Mark Steyn. I've met him a few times, and he's actually he might very well have been sicker than Simberg in the interim. I know he suffered a grave threat to his health fairly recently.
He had some heart attacks, and he was in a wheelchair at the trial. Now, how serious his health problem is, I don't really know. Also, your viewers probably know that Steyn was representing himself. He had a lawyer earlier in the case. I mean, the case went on for 12 years. I think he had that lawyer for 10 years, but he fired him a couple of years ago. I don't know why he fired him, whether it was because he couldn't afford him, or whether it was a strategic matter of some kind. He thought it might play better to the jury without a lawyer. He was assigned a couple of lawyers by the court. I don't know whether he was paying those people or not, but who sat with him. And they didn't say anything in the court while I was watching, but they filed motions, and I read the motions, and they were competently done. But that being said, almost all of the work at the trial was done by the lawyers for Simberg, who were brought in by CEI.
Mm-hmm.
And so Steyn did do some cross-examination of Michael Mann, but all the defense witnesses on the defense case, and there were like 6 or 8 of them, were put on by CEI's lawyers, even though CEI is not a party anymore. CEI had been dismissed out of the case. But all the witnesses were put on by them. And almost all of the cross of Mann's witnesses was done by them. And they were very, very good, very effective.
So can I ask you, so where did things go wrong? This is a jury case, I assume. And I assume there was venue selection for DC in particular.
Yeah,
did
sure.
it happen in DC? Could it have happened anywhere? Can people just pick their venues wherever they like that Alabama Mercedes case? Where you get the people who have an itch to do something, certain Trump cases, et cetera. What do we do about venues? And was that an issue here?
I don't know that any motion to change venue was ever made. And so what would I say about that? I have quite a bit of knowledge about the federal venue statutes. For these purposes, I think that Mann wanted to shut up Steyn and didn't really care much about Simberg. However, Steyn had quoted from Simberg, and Simberg had posted it on the blog of the Competitive Enterprise Institute. The Competitive Enterprise Institute is located in Washington, D.C. So you can bring a case. One of the provisions for the venue is you can bring it where a defendant is located. Another provision is you can bring it where the damage occurred. Now, you could say, well, did damage occur in DC here? If that was the only hook that Mann had to get the case into DC, the defendants may have challenged it, although Mann probably would have said, my grants come from DC. And so that's where the damage occurred. Of course, the jury ultimately found there was no damage from lost grants. So that may have been a very weak hook for venue, and maybe Mann realized it, which might be a reason he was clever enough to add Competitive Enterprise Institute as a defendant. But with Competitive Enterprise Institute as a defendant, I think the defense made a decision that'd be hard to second guess, that it would be very hard to challenge venue.
Mm-hmm. So what about, how do things filter out? I read some of your earlier blog posts on this, and it just doesn't seem like Mann has a leg to stand on scientifically. And how do you manage to win a defamation case when your underlying data are, flawed, manipulated, weak?
Well, this is a very interesting thing. You say Mann has no leg to stand on scientifically. And I've looked at it, and if I were cross-examined, I would have to admit I'm not a climate scientist, which I'm not. But I also believe that science is the belief in the ignorance of experts, and that I'm as capable as anybody else of looking at the question of does this data support this hypothesis? Or if somebody says the data has been manipulated in X way, and I look at it, I'm as capable as anybody else of making an assessment of that. Yeah, I don't think you have to be a scientist to do that. As I described, Simberg put on these 2 guys who had done the work in the early 2000s to show that Mann had, in fact, manipulated his data. He had failed to report adverse verification statistics. and he had improperly minimized the uncertainties of his work. And Mann put on no witness to the contrary on any of those points. But what did he do? He pointed out that all the scientific societies are on his side, that the National Science Foundation did some kind of a investigation into him and found no basis to accuse him of fraud, which is not the same as exonerating him, but he claimed it was an exoneration. And others in Europe also investigated, and these would be, again, academic institutions or scientific societies, investigated the dispute and found no basis for accusing Mann of scientific misconduct. Now, I think they're dead wrong, but they never specifically address the scientific and mathematical issues raised by McIntyre and Weiner and others. They're basically, I mean, Mann is too valuable a guy to their team to throw him under the bus. And when all the scientific societies stand up for him, how many lay people are really going to get past that and look into failure to report verification statistics and whether that's important?
Yeah. I'm just going to read from the actual article by Stephen McIntyre and Ross McKittrick. The hockey stick shaped temperature reconstruction of Mann, 1998, has been widely applied. However, it has not been previously noted in print that prior to their principal components analysis on tree ring networks, they carried out an unusual data transformation which strongly affects the principal components. Their method, when tested on persistent red noise, nearly always produces a hockey stick-shaped first principal component and overstates the first eigenvalue. In the controversial 15th century period, the MBH 98 method effectively selects only one species, bristlecone pine, into the critical North American principal component, making it implausible to describe it as the dominant pattern of variance. Through Monte Carlo analysis, we show that MBH 98, that's the Mann benchmarks for significance of the reduction of error statistic, are substantially understated. And using a range of cross-validation statistics, we show that the 15th century reconstruction data lack statistical significance. So basically, it sounds like almost literally, if bristlecone pines had cherries, this is cherry picking.
Yes, and by the way, Ross McKittrick also testified at the trial. And from the part you read, in the part you read, the omission of that, what's called the RE statistic, the reduction of error statistic, is mentioned. That's what McIntyre testified, but McKittrick testified about the subject of the of Mann's methodology, selectively seeking out those data series with a hockey stick shape to give them prominence in the reconstruction. And that was another flaw in Mann's work. Again, I think McIntyre and McKittrick are completely right about it. McKittrick is the guy who testified about it at the trial. They didn't really cross-examine him on that issue. I mean, the testimony of McKittrick was things like, you've been a fellow at the Cato Institute, haven't you? You've been a fellow at the Fraser Institute, haven't you?
Right. Yeah, that's ad hominem stuff. Yeah. I read the Agony and the Ecstasy when I was in high school by Irving Stone on The Life of Michelangelo, if I remember correctly. And the quote is there. I'm sure Irving Stone didn't, as old as he was at the time, didn't overlap with Michelangelo's life. So we don't know if it's a precise quote, but the concept was when he had, saw a piece of stone, they're like, how did you make La Pieta or La Pietà? And the quote is, "Well, I took away everything that wasn't," or the statue of David, I guess. He said, "I took every piece of stone away that wasn't David. Therefore he created David out of that stone." Well, that's a nice trick if you can do it. And it sounds to me as if there's a little bit of that sculptural element. If you want the hockey stick, you take away all the parts out that are not hockey stick. So, so I don't want to be, brought in front of any SLAPP or anti-SLAPP, whatever it happens to be, by saying that Michael Mann may be the Michelangelo of data sculpting.
Well, that sounds more flattering. So I suspect if Steyn and Simberg had said that, they wouldn't have found themselves in the dock there.
Yeah. I got to tell you, as a side note, I interviewed John Ziegler about a year ago, and he wrote a book on the Joe Paterno scandal, the Penn State one. I think he's a graduate of Penn State. And he really went over the thing with a fine-tooth comb, which is for taking lice out of your head originally. So he used this fine-tooth comb, and there's a fair amount of lice to be found there. And he, basically Jerry Sandusky is not the Jerry Sandusky of Jerry Sandusky's either. He's an oafish kind of, a naif and kind of a football loving, kind of regular guy. And he got blindsided by a lot of the his kind of anhistoric or his habits that were kind of from a different era of camaraderie and Boy Scout-ish stuff and whatnot. I think he was an Eagle Scout himself, and campfire attitudes that don't go over today. And a lot of the quote unquote eyewitnesses were never eyewitnesses, and there's a lot of misapplication of information and overlapping, and frankly a lot of kind of pushing towards putting the result in advance of the data, which is oftentimes the way science actually works according to the Michelangelo theory of data sculpting. So that's a separate thing. And I commend my readers, and maybe in the great Manhattan Contrarian, to watch this at some point and or pick up his book, because there's a lot to be said that Sandusky was not sophisticated. Yes, true. Maybe he may be not the brightest bulb on the tree. Okay, fine. But this kind of serial molester of boys, apparently not. And the accusers were never there. It's a whole big story. It's an interesting one. I don't know if they could have brought him into this trial. I think it's too late to make Jerry Sandusky is into a compliment. But Sandusky languishes in jail nonetheless, or prison.
Well, yeah. When I wrote my several blog posts about the Mann v. Steyn trial, a couple of commenters commented that I shouldn't be so sure that Sandusky actually did anything wrong. And that, I think, like you said, a lot of the witnesses were not eyewitnesses, and there was some recovered memory issues which were dubious. And then in the trial, Steyn and Simberg, in their defense, and particularly Steyn, were saying the harshest of things about the corruption of Graham Spanier, the president of Penn, who had been in charge of these investigations. And one of my commenters said, well, Spanier was indicted on a host of felonies, and he was acquitted of all of them and only convicted on one misdemeanor and only served 2 months in jail. So, however, all that having been said, nobody at this trial had an interest in standing up for Sandusky.
So you can only shovel some. Yeah. So, separate question: was Mark Steyn unlikable at the trial? He's a very bright guy. I don't know how he looks today, and or in a wheelchair, and whether he's weak and whatnot. But he was always a kind of a force of nature, and he's a very articulate guy, and he has a particular way of being. And he might come off as arrogant because I don't think he has any doubt about his articulation and ability to think clearly.
Well, the point I make about that, Randy, is if this was not a politically charged case, I don't think the jurors would have particularly reacted badly to Mark Steyn, but they clearly did react badly to Mark Steyn. And I think it's because they don't like his politics. And I don't know that there's anything he could have done about that. They're just not going to like his politics.
Yeah. No, I've heard of that. Without delving too deeply, we'll take this offline perhaps, but I have a case that I would like to go to the Supreme Court. I've been through the first district and whatnot, and my own medical career was cut short by political act, in the sense they didn't like that I didn't think narcotic addiction is a disease. Mind you, I think it's a bad thing, and it's a trauma in lives, and it can certainly kill people. And there are lots of bodies buried and whatnot, sadly, and God bless them and all that kind of stuff. But but car accidents as well, can kill many people. Nobody thinks of car accidents as a disease. So something being dangerous doesn't mean it's a disease per se. I consider them traumas, and you can look at narcotic addiction if you like as a trauma, like breaking your hip is a bad thing. But it's not a disease per se. It may be emblematic of other diseases underlying. You might have osteoporosis, you might be demented, you might fall down a lot, you might have bad balance, etc. You might have decided to kill yourself and break your hip. Anyway, one of the counts against me back in 2014 was that I didn't consider addiction a disease, as I was treating people by gradually tapering them with Suboxone, and they didn't like the fact that I was gradually tapering people. And so it's in a sense a political aspect, an application of what you think is right, layered on to how people are acting in good faith.
Well, of course it's political, and tell me I'm wrong, but as I hear you talking about this, all I can think is, if addiction is a disease, then everything about treating it is covered by insurance. And if it's not a disease, then a lot of it might not be covered by insurance.
You're absolutely right.
Profession has billions of dollars at stake in this.
It's been a very big rent-seeking accommodation to make addiction a disease. Now, mind you, alcoholism is equally a disease, but we never treat alcohol with replacement alcohol. If you have a whiskey problem, we don't give you this nice clear water-like liquid every day, vodka. But somehow that's become the only treatment for somebody who's addicted to heroin and whatnot, is to give them replacement drug. And some people have done very well by it, not necessarily the narcotic addicts, but the treatment facilities. But it's been a very good industry wide application. Methadone and Suboxone and whatnot have become licenses to print money for certain aspects of medicine. But that's another day, another topic. So do you feel as if as if Michael Mann hockey stick is vindicated in the public mind as truth? I mean, is that the end result here?
Randy, I can't speak to the public mind, but Mann is clearly now unleashed upon the world to claim and to crow about his vindication. And there's nothing to stop him. Whereas Steyn and Simberg are clearly reined in by this verdict. And I mean, once there's a verdict against you on a defamation claim, it's a huge mistake to keep repeating the same thing. And a guy who just learned that lesson is Donald Trump, who had a verdict against him, and he kept repeating the same thing. And now he's got an $83 million verdict against him, all of which is not real damages. It's mostly punitives and some called general damages. But he's got an $83 million verdict for repeating the same thing after there was a verdict against him. So clearly Simberg and Steyn are reined in. Well, Steyn is a guy who should not be reined in this world, and maybe the Supreme Court will ultimately reverse that. Meanwhile, there's not really that much of a shortage of people ready to criticize Mann. There's lots of people ready to criticize Mann and who aren't going to be silenced by this verdict. But the problem is that the whole scientific establishment and the scientific societies back Mann because, again, big money in the hockey stick and the assertion that humans cause climate change, which the hockey stick is supposedly the proof of, but it's fake proof.
So we're kind of rounding out the hour here, and I'd like to, give you a chance to ponder other topics on your own. But while I still have you, I can't. I was kind of grazing on X, and I found a thing that interested me, kind of about Henry's law, which is regarding gases and liquids and whatnot. But basically, solubility of a gas decreases with increasing temperature of the liquid. Mm-hmm. In particular, carbon dioxide has a very sharp gradient that it gets dispelled more as the temperature rises. We've all seen Coca-Cola cans. You have a cold Coke or whatever, you leave it out, gets warm, you open the warm can, it goes spraying. So we've all had graphic demonstration of carbon dioxide leaving warmer water. And so the question that kind of popped into my head is did the climate experts get this backwards, that perhaps the Earth is being warmed by, say, that, I don't know, big nuclear fusion reactor at the center of our solar system, bringing heat and light and warmth and metaphors to us, that might have caused some warming in the seas, and the seas release more carbon dioxide, and therefore what we think is the carbon dioxide bringing on more heat, it potentially, and if we stipulate that the Earth is warming, which is another question, but if we stipulate that, is it possible that the heat came externally and applied and so forth, and that once it's done, the waters might be a little warmer, they expel more carbon dioxide, and we notice more carbon dioxide, and we think A caused B, kind of a post hoc ergo propter hoc fallacy.
Randy, you're not the first person to think of this. And there are people who asserted vehemently, vociferously, that in fact the increase in carbon dioxide is brought about by increase in temperature first. But when people have asserted that proposition in comments on my blog, others come and tell them they're idiots and shut them down. Now, I don't have a view on it. I mean, I certainly do have a view that what you say is right, that if the warmer temperatures came first, that would cause outgassing of gases, including carbon dioxide from the ocean. That is how it works. But on the other hand, if the carbon dioxide came first, that could cause some warming of the atmosphere too, without outgassing from the ocean, or it might also cause outgassing from the ocean, which would be a positive feedback. I don't think the data on this are so noisy. There's so much inaccuracy in what can be measured that I don't think it's possible to have a definitive view on that. But there are definitely people vociferously on both sides of that issue, including in the climate skeptic camp. There are people who say, don't raise that reverse causation argument. It's wrong, and it makes you look like an idiot. So there are people who say that. I don't think it makes you look like an idiot. I don't know that it's wrong, but I also don't know that it's right.
Yeah, when you look like me, already halfway to idiot, it doesn't really hurt very much. I always wondered about that kind of thing. Like when somebody says, "Oh, he's a lot smarter than he looks," does that mean you look stupid? And is the converse better? That, oh well, he's he's a lot. I don't know.
He's a lot smarter than you. The famous line is, "Wagner's music is a lot better than it sounds."
I have one. I had an intern,
Mark Twain.
I had an intern a long time ago, and he was a Harvard guy, and I had high expectations. He was on my little tech team, and he belonged to a very obscure sport. I'll make it. I don't know, what should I make it? Archery, so as not to label him, but so I used to say, for a Harvard graduate, he's a really good archer. Yeah, that's anyway. So we're gonna call it a day, probably.
Okay.
If you have any last word before I have my ultimate ones, if you have penultimate words, say them now.
Nothing more from me. I've had my say for today.
Okay, wonderful. So people want to help support my video cast and have wonderful, amazing guests such as Francis Menton on. You can go buy my book. It's called Overturning Zika. It does just that. It's true to its title, but there's a little bit of lag time as far as people understanding that Zika microcephaly was not all that. Zika is a real virus. Microcephaly is a real phenomenon. It just so happens A does not cause B. Getting back to causation, correlation, and whatnot. But there's been no reformulation, even though it has not recurred anywhere on Earth, probably even as early as 2016. Never happened. No increase in microcephaly. The theory would have predicted 1 million extra microcephalic births around the world. Thank God that never happened. There's been 0 additional microcephalic births around the world since 2016, and nobody retracts the theory. There's money there. There's been thousands of articles on Zika and microcephaly and whatnot since then, and it's been a very good industry, cottage industry, for a certain small tranche of the scientific world. And when I say scientific, I mean
pseudoscientific.
Thank you, and we're going to call it a day on that. Thank you so much, buddy, for joining us. I look forward to seeing you again.
My pleasure.